Welcome to our new program, Courting Justice. Here we would like to discuss contemporary issues related to various important subjects. Today, we thought that we would discuss something about transitional justice. We all know about justice, but what is transitional justice? And today, we are also discussing that very important dignitaries here in Sri Lanka, because the United Nations High Commissioner for Human Rights, Said Rad Al Hussein, has arrived in Sri Lanka and he's visiting various places and meeting people. In this backdrop, we thought we would like discuss a couple of important issues, questions with a very eminent panel. Now I welcome my panel here. First, I would like to welcome Dr. Pakeswathi Saranamuthu, Executive Director, Center for Policy Alternatives, CPA. Welcome, sir.
Thank you.
Then I have Dr. Nimalka Fernando, Director, Women Political Academy, also Chairperson of the International Movement Against Discrimination and Racism. Welcome.
Thank you.
And finally, I have Gihan Gunatilaka, researcher, senior researcher from Verite Research. Thank you. Welcome. So I think it's opportune time we discuss a couple of issues. I start with Gihan. Gihan, since the High Commissioner for Human Rights is also here, there's a lot of discussion about Geneva Resolution, the High Commissioner's office, the report, hybrid mechanism and all these things, and a lot of people discuss these things without having real meaning. I would like to ask you right away, what's the report we discuss? There's a lot of confusion.
So Sudarshan, the OHCHR, there's the Office of the High Commissioner for Human Rights, launched an investigation into Sri Lanka based on a resolution that was adopted at the Human Rights Council in 2014.
Okay.
And once that resolution was adopted and it mandated the OHCHR to investigate into certain alleged human rights violations and violations of international law in Sri Lanka, the actual report was tabled before the Commission last September. So this report contains the findings of the what we call the OISL, that's the OHCHR investigation into Sri Lanka.
Sri Lanka.
Just to summarize what the findings were very briefly, it found that both sides of the war, the LTT and the government forces, committed certain violations of international law, including war crimes and crimes against humanity. So they found that there was evidence of these crimes. Of course, it framed the report as a report on an investigation into human rights violations.
Okay.
So it was not a criminal investigation in that sense.
There's a difference between criminal investigation
That's
and the
right.
human rights investigation.
That's right.
Can you just
So
also
it
shed
also
light on?
has
Yeah.
a lot to do with the burden of proof and the
Yeah.
evidence gathered,
Right.
because as you know, the OISL team
Yeah.
did not have access to a lot of information in Sri Lanka.
Right.
So given the access that they had, I think it was more prudent to frame it as a human rights investigation. And also the Council's mandate that was given to the OISL was essentially on human rights, because it's a human rights council. Of course, the findings were quite interesting. It's interesting that the findings have not been discussed at great length in Sri Lanka.
Yes.
We don't really focus on the findings themselves. But the term hybrid court really comes from the OISL report.
Okay.
It recommended that both a mechanism that has both international as well as domestic participation would be suitable to deal with these allegations.
Okay. Gihan, if I may ask that, okay, that the Council has mandated the Office of the High Commissioner for Human Rights
That's
to
right.
investigate,
Yes.
and that was a human rights investigation, not a criminal investigation.
Essentially, it was a human rights.
In a criminal investigation, that burden of proof is beyond reasonable doubt.
I mean, criminal investigation will also have access to the perpetrators.
Right.
So here there was a problem in access as well.
Yeah.
Of course, given the evidence that was made available to the OSL, I think the report comes out with these findings that there is evidence of war crimes and crimes against humanity. But it recommends that further investigations are taken on and a hybrid mechanism is used to prosecute alleged perpetrators.
So the first investigation asks another investigation in the nature
Essentially, because of the nature of the investigation. Yes.
Now I turn to Dr. Nimalka Fernando, because you were in Geneva during the report was launched, and also subsequently there were I think when the report was launched, even before that the foreign minister visited Geneva, and also he discussed the measures that new government is willing to take. And then the report came and there were informal discussions. Afterwards there was a resolution. There's a confusion about the report and the resolution also, and the government response. And some people claim that this is a Geneva resolution and it's owned by somebody else. Nimalka, I would like to ask you, what's in the report and what's in the resolution? What's the difference between these two?
I think we should understand the fact that we came to this level of having to request UN to intervene in an investigation is because there was no credible national mechanism. We went through commissions of inquiry, commissions, the former president appointed one-man commission, Mahanama Tilakaratne commission, so on and so forth. The affected communities and the human rights community in Sri Lanka got involved in this. The affected communities participated in the process of giving evidence, giving their side of the story, revealing what happened to them during the war. And this report, we must know, is also not about the North and East only. The Ratupaswala, Roshan Chanaka's mother, wanted justice. In that context, when justice failed within a domestic environment, using national mechanisms, the victims and the affected people had no option, including the human rights advocates like us in Sri Lanka, but to seek the next best option of reaching international forums like UN, because Sri Lanka, after all, is a member of the UN, and this is not the first time that the Sri Lankan issues like human rights violations have gone before Geneva.
But the former government accuses the human rights defenders as well as victims of being infringing the sovereignty of the state, and also they went on accusing betraying the country kind of.
No, this is why I think the Sri Lankans have very short memory. So that is why I'm reminding ourselves, and we as citizens have to remind ourselves that the state of Sri Lanka has failed to address these issues effectively, and especially within a conflict of our nature, that no confidence of community was what was challenging the Human Rights Forum. So therefore, we waited since 2006, 2005, 2007, 2008, 2009 for the government to establish a credible national mechanism to address this. The LLRC came and went, and the recommendations we know did not deal with. But fortunately, I would say, most of the incidents of the LLRC have been noted in this report, OISL, because they were grave violations. And this report dealt with war crimes, crimes against humanity, and a failure of effectively implementing humanitarian laws, which Sri Lanka is party to. And of course, LTT violations were also mentioned. Now, you have a report. What do you do with the report? The report is not a binding instrument. This is not a convention. Report deals with facts. What do you do with it? Within the larger context of people asking for justice, affected communities crying, looking for their family member who had disappeared. Some families have surrendered people to the army during the last stages of the war. And we saw 350 people in the Vaunia camps, the issues of resettlement, issues of disappearances. And this report asked several questions from us, from the international community, from us as Sri Lankan citizens, and from the Sri Lankan authorities. How are you going to deal with this?
Right.
Broadly, the report has issues of accountability, issues related to reconciliation, issues related to reconciliation, accountability, and human rights.
Right.
Each issue or subject requires an effective response from the state, from the Sri Lankan government. It is within this context that we form what is called a resolution, and this is a building up of this discussion since 2012. 2012, the urging Sri Lankan government to recognize something has gone wrong. It is not only urging the Sri Lankan government, but we as Sri Lankan citizens have to answer the affected Sri Lankan citizens in this country as human rights defenders. We ourselves had to find an answer to a person like Sandhya Eknaligoda, who will come and ask me, what shall I do? I went to the police station. I went to the Humagama Magistrate Court. I went to the Human Rights Commission of Sri Lanka. Nothing is happening. They can't find my husband. Where shall I go? Then she goes to Geneva. Then Geneva has to find a response. We have to find a response. So it is within this context that this resolution is also giving an answer to Sandhya. This is not giving an answer to the politicians of this country. The resolution is giving an answer to the affected people, the victims, as to what kind of mechanisms Sri Lankan government can put in place in order to deal with their pain, their issue of how to deal with justice. So it is within this context that we have the resolution, which deals with not the final issue of justice, but how do we now create investigation into allegations of crimes, war crimes, violations of human rights. So there is this issue of what is the best way to handle this issue of justice, whether it's a national court or a hybrid court, or whether it could be a mixed one, because the national failed. Then what do you do with people who may not want to go to court? They may want to just need closure. I need to see. I mean, there are family members who would say, I actually want to see the bones. It's very sad for me to say that, of my child. So that's the issue of her pain. She may not go to court. So all and reparation for those who have lost land, those who have lost their livelihood, and the issue of missing, the issue of non-recurrence. So it is within that context that the resolution got built in. How do we effectively provide mechanisms with regard to security sector reforms, legal reforms, new laws to be brought in, and justice to affected victims. So this gives us the framework of developing mechanisms and effective response to what the findings have revealed in the OISL.
Yeah. Thank you, Nimaka. In short, that in the absence of credible national mechanism, victims and the defenders had to turn to the UN system, UN human rights system, and Sri Lanka is a signatory to the UN various conventions, so under obligation to fulfill these obligations. And then in that case, that case was taken to at the UN Human Rights Commission level, Council level, and the investigations were done. Afterward, a resolution was adopted to make sure that the investigation, the report was having some impact. So in that case, that you were also talking about various measures, not only the justice, but also the truth and the reparations, and also Sri Lankan foreign minister has promised that there will be 4-pronged approach, including non-recurrence, guarantees for non-recurrence. Now I'd like to ask Dr. Saranamuthu. Okay, now as Dr. Nimarka Fernando explained, there was a resolution. Now what happens afterwards? So who's going to act upon this resolution and how it is happening?
It's also a consensus resolution. I forgot to mention
I think
that.
the first point that needs to be made about the resolution is that this is a resolution that is co-sponsored by the government of Sri Lanka.
Right.
So the government of Sri Lanka has direct ownership of this resolution. It has an international obligation to implement the recommendations in this resolution. So there is a primary responsibility as far as the government of Sri Lanka is concerned vis-a-vis the resolution.
Right. Right. So nobody can say now it's something outside, like earlier,
Absolutely.
all 3 years under the last government.
Absolutely not.
Yeah.
We can't disown this resolution.
Right.
We are co-sponsors of it.
Right.
And by saying that we are co-sponsors of it, presumably the government is fully aware of what the resolution contains and what it adopted and presented to the Council and which is passed in the Council. And it has therefore voluntarily taken on a primary responsibility in initiating a process of transitional justice in this country. And that process is absolutely necessary for national unity, for reconciliation. The government has made the point, and indeed that point should be stressed, that we are doing this not because this has been dictated to us by an international community or certain members of it, but we're doing this because we feel now that it is absolutely vital that we do it for ourselves, that for unity, for reconciliation in this country, this is absolutely vital.
So I think you made a very important point earlier. Under the last regime, the approach was different. They basically said that Geneva is a place where conspiracies are hatched, and there are local counterparts who goes there and who actually co-conspire. And now this government, new government's approach was completely different. That they they believe that they are accountable to the people of the country, so they think that they should do something, and they own the process, and therefore they also win some kind of support from the international community as well. So is there any progress afterwards, after the resolution was passed? It was passed in September. Now we are in February. How do you assess the period and the process? And
well, I think there has been some progress, but I will say this, I don't think there has been sufficient progress. I would have liked to have seen more things happen.
Right.
There has been progress in terms of some confidence-building measures. Often referred to are the appointment of the governors in the north and east as people without military pass. The return of land is another thing that is pointed to.
Right.
But there are lots of other things that can be done to build up the confidence of the people in the north and east. Because the process of transitional justice, at the end of the day, ultimately its credibility and legitimacy resides in the extent to which it provides a sense of assurance and security to the victims. It has to be victim-centered. So now, in addition to those kinds of confidence-building measures, the government says that it is going to set up, it has set up, and in fact I am a member of a task force that has been set up for public consultations with regard to the kinds of mechanisms that ought to be established to deal with transitional justice, and this will start happening in the next weeks and probably take a good number of months, depending almost entirely, in my opinion, on how many people actually come forward to provide information, give their advice, give their proposals with regard to what kinds of institutions we should be setting up or mechanisms that we should be setting up.
okay, I think especially since you mentioned about the task force, I think there's a lot to discuss about that, and we would like to have more discussion on that. But before that, dear viewers, we would like to take a break, and afterwards, please hold on. We'll have a very interesting discussion in front of us. Hello again. Court in Justice, our new program, a discussion forum to discuss various interesting subjects. This program is brought to you with the courtesy of South Asian Center for Legal Studies. I was talking to Dr. Saranamuthu regarding the resolution and also the implementation. Can you also briefly tell us about the main points in the resolution? What are the main subjects that government is supposed to implement?
Well, I think the government is seized at the moment with the process of transitional justice that is called for in response to the points contained in the resolution about the allegations of war crimes, the need for reparations, the need to deal with the question of disappearances, the changes that are required in terms of domestic legislation, the need to create new institutions that will inspire trust and confidence in the victims in particular with regard to getting justice. So they're talking, therefore, they're taking on, indeed, the points that were made by the foreign minister in his speech at that September 2015 session of the Council, where he talked about a number of mechanisms that the government was contemplating. So the resolution notes that and encourages that, and the resolution also talks to a certain extent about the composition and the structures of these mechanisms, and most importantly, of course, it does talk about the active participation of internationals, where there is a lack of experience and expertise, but most importantly, and I think this is the point that absolutely has to be stressed, this will be a farcical process if the people most directly affected by it do not participate in it because they think it is going nowhere and just being done as a gesture to tick a box.
So credibility is important.
Absolutely.
In that case, no? Yeah. So also I would like to come back to you about the task force and the other things, but Gihan, is this resolution, and as Sarah mentioned that it's owned by Sri Lanka, and Sri Lanka is doing not because somebody is dictating to us, but we want it, we want to do it. Is it really implementable actually? And is there any desire to do that, and also practicability? I'm just asking because on one hand we have a constitution and we have to abide by the constitution, and also the president has also mentioned that we do whatever we do based on our constitution. So is it really in contradict with the constitution, or is it possible under this present constitution to handle this?
I think it's important to understand the difference between voting in favor of a resolution and co-sponsoring a resolution.
Okay.
See, Sri Lanka co-sponsored this resolution, which means that Sri Lanka is actually an architect of this resolution. Okay. So I have doubts about whether the Sri Lankan government would ever co-sponsor something that it is not prepared to implement in full.
Okay.
And we have to assume that the government went through a process of reflection as to whether this is possible when it finally decided to co-sponsor. See, the decision to co-sponsor is actually quite important because it wasn't as if it was a resolution that was drafted by some other country and Sri Lanka merely voted in favor of.
Right.
It is something that Sri Lanka co-sponsored, which means the contents are actually owned by the Sri Lankan state and the government. So if you look at the clauses in the resolution, there are 20 operative paragraphs. And these operative paragraphs are basically the commitments that the Sri Lankan government has put forward through the resolution. And each of those operative paragraphs are fully implementable. Under the constitution, under the current legal system, it's fully implementable. There will be, of course, a need to introduce certain laws that enable some of these commitments to be fulfilled completely. And that is also something that the government has committed itself. Right. But under the constitutional framework, there are absolutely no impediments to implementing this resolution in full. There are, of course, questions raised as to whether this is possible. But if you look at the constitutional framework quite carefully, for example, the language used in the resolution is very clearly language that has been borrowed from the Sri Lankan constitution. Right. I'll give you one example. In one of the operative paragraphs, it talks about general principles recognized by the community of nations.
Right.
Now, that is something that is usually referred to in the context of customary international law.
Right.
Now, instead of using the words customary international law, it uses these words, which is directly borrowed from the Sri Lankan constitution.
Exact words.
Exact words.
Right,
So it is very clear that the Sri Lankan government actually participated in the drafting of this resolution.
Okay.
So it is not possible to assume that now we are in a position that that we are impeded in terms of fully implementing the resolution because of constitutional framework.
Right.
I don't buy that argument.
That brings a very interesting question. I'll ask Nimalka right away. Some critics during the Geneva resolution time actually said that it was a mistake. Sri Lankan government actually co-sponsored this. So, going by Gihan's point, I'm just actually asking to provoke you. What do you say? What do you say about that? Is it a wise decision to actually co-sponsor?
Now, is it a mistake? Let me quote from the resolution.
Right.
Is it a mistake to ask this question from ourselves that encourages the government of Sri Lanka to investigate all alleged attacks by individuals and groups on journalists, human rights defenders, members of religious minority groups, and other members of civil society, as well as places of worship, and to hold perpetrators of such attacks to account and to take steps to prevent such attacks in the future. Is it a mistake? These things happen in Sri Lanka. Right. Is it a mistake that the Sri Lankan government co-sponsored this?
It affected all of us.
It affected all of us. So Sri Lankan government has to take steps for non-recurrence of this kind of situations, and also to hold perpetrators accountable for that. Is it wrong for Sri Lankan government to welcome to review the Public Security Ordinance Act, and to review and repeal the Prevention of Terrorism Act, and to replace it with anti-terrorism legislation in accordance with contemporary international best practices? Is this not what a modern state has to take note of? On one hand, we have to deal with terrorism, so we need anti-terrorism legislation.
Right.
But the anti-terrorism legislation has to be built, developed on international standards.
Okay.
Is it? I want to read, because this discussion is happening in an uninformed context.
Right.
You know, the Sri Lankan citizen public are not aware of what is in this resolution.
Yes.
It is these Veeravansas and Gaman pillars who are creating this propaganda to say that there is some conspiratorial language in this resolution, including some academics who served the Rajapaksa regime. This language is very clear. We have to deal with the injustice that happened. Is it wrong to encourage, we as citizens, you know, this should have been written by us.
Right.
I am ashamed that this came from an international forum.
Right.
This should have been written by our politicians. This resolution should have been drafted by our parliament members, because finally, like the president mentioned on 4th February, this is after all about the dignity of my country.
Right.
This is the dignity of our armed forces.
Yes.
They have to behave properly. The police have to behave properly. The Human Rights Commission has to function properly. So we have to restore the dignity of not Sri Lankan state like the Bhumi or the land. Right. This is the dignity of the citizen who has faced violations with no justice. This is about women who were raped in a war context. How do we deal with it? So this resolution to me is something that we citizens of Sri Lanka should have written, and also it is talking about addressing these issues, and also welcomes the return of land, encourages the government. I mean, in a way, it for me it is shameful for somebody to say accelerate. The land has to be given back to the people, and the president has very clearly is saying, please, we want to give the land back.
Right.
And I think we need to support that. All this language is there. Is it wrong for the farmer to get back the land? Is it some external conspiracy that the farmers did the farmers conspire with imperialist forces to get back their land? No, they want their land back, and we have to find ways and means of giving that land back. That is all there in this resolution.
Okay, so I think you are also supporting what Gihan has said. This Sri Lankan government is owning this thing. Actually, that's the discussion, and you mentioned very clearly, okay, the instances. So, in other words, shall we say that this resolution and also the Sri Lankan government's commitment to co-sponsor it reflects the change of status quo, where there's a new government coming into power with new aspirations, and like the people's movement who actually which supported this change, the aspiration of this people's movement also contained in this resolution. So then we should collectively own this. Also, you mentioned about the misinformation campaign. That's why Sri Lanka Rupawahini Corporation, in collaboration with the South Asian Center for Legal Studies, is trying to have this kind of discussion forums. We did one in Tamil, one in Sinhala, and this is the English one. So we would like to continue this kind of discussion. Sara, now I would like to ask you, okay, the implementation. Now Nimalka has very clearly mentioned, okay, what are these things and why it is important. So tell us about this task force and also your role in it.
Okay. Well, there is a Prime Ministerial Action Group under which there is a steering committee, and then a secretariat that's dealing with issues of reconciliation, and the secretariat is the body that's immediately above this task force that has been set up. There are 11 of us. The task is to ascertain public opinion and views about the mechanisms necessary for reconciliation. Yeah? The task force is composed of 11 members from all communities from all over the country. The consultations will take place at a provincial level, but in the North and East in particular, it will also take place at a district level. So that it will be more focused and concentrated. The consultation will probably entail more sort of town hall style meetings, but also focus group discussions with regard to particular issues. The government has assured us, and we are all civil society, members of civil society, and we've all agreed to be part of it, on the assurance that the report that we submit to government will be made public. Okay. And in that sense, we see it therefore as a reference point, a standard against which to assess what actually comes out in terms of the mechanisms that are subsequently established.
So that means that there will be a consultation process led by a civil society initiative, but which was sponsored by the government.
Well,
but
the government has asked us to do it.
Yeah, but then you will be actually publishing the report by yourself, I mean, as a task force.
Well, the government says that once the report is handed to it, that it will publish it.
Okay. Right.
And I can assure you that if the government does not, that civil society members of the task force will publish it on their own.
Right. And we hope that going by all the statements and government will publish it. And so that will be a great opportunity for people of all corners of the country to come up with their own issues. As Nimalka mentioned, it's not only about North and East. It's about the whole country.
Absolutely.
So resolution
it's
discusses
entire
island-wide consultations we are doing. So I think that's great news. So we can have more. So what's the time frame like?
Well, I mean, I think the time frame at the end of the day will depend entirely on how many people come forward to provide their views, their ideas, opinions, etc. But otherwise, it's roughly approximately going to be a 3-month period in which the consultations will take place.
Okay. So, Gihan, my question now is that there's a parallel process going on, almost like a consultation for the new constitution. There's a public opinion is actually there's a consultative committee led by Lalu Vijayanayake. Now it's going places, and that is also they also have a time frame of 3 months, and new constitution is going to be enacted afterwards. And there's this transitional justice process. How do you see that two processes going in separate ways? Is it how do you actually? What's your take on it?
So there is a debate
Right.
on whether this transitional justice mechanism should come after the constitutional reform process.
Right.
So there is a school of thought
Right.
that it should come afterwards because the constitutional reform process must take precedence in terms of the priority. I think if you ask the question, should transitional justice come after the constitutional reform process, you're asking the wrong question.
Right.
Because these two agendas, if I can call it that, are inextricably linked.
Right.
And I think if you look at the election results in the north particularly, you will see that the political solution and the demand for justice are linked and they cannot be sort of separated.
Right.
I think it will be a mistake to postpone the transitional justice mechanism because this constitutional reform process is going forward. The reason is that there are some elements of the transitional justice process that can be implemented immediately, and the task force and the national consultation is one of them.
Right.
But also there is a strategic reason. See, the moment we are in right now, in terms of the space that has been carved out for transitional justice, the momentum that has been created, we have to seize. Because if we don't see progress in 2016, we will not see progress at all. And I think it is important to capitalize on this momentum and seize the opportunity while we have it. If we wait for too long and keep postponing, we will get into the same trap of broken promises. So I think the government has to be willing to come out with certain steps, measures that are easily implementable in the short term. And one is, of course, the national consultation. But in addition to that, they can set up one of the 4 promises that it made. It promised to set up a special court. It promised a Truth and Reconciliation Commission. It promised Office of Reparation, and then an Office of Missing Persons. And I think this final Office of Missing Persons can be implemented and can be established in the short term.
Right.
So there are some steps that can be taken immediately. And I think there's also some, as you mentioned before, there's some misinformation. There's a lack of clarity as to precisely the time frame that the government is going to implement all these commitments.
Yeah.
And I think a roadmap that highlights and that explains the time frame quite clearly should be published alongside the national consultation, so people have an understanding as to what the plan is. So I dispute the claim that transitional justice must come after the constitutional reform process, because these are linked, and also you can start implementing certain components of the transitional justice process immediately, which will build confidence, as Sarah mentioned.
We are listening to Court into Justice, actual Court in Justice. Nimalka, now there's an important question. It's about 2 processes, and also that Gihan says that okay, that it should go hand in hand, and also certain things can be implemented. But end of the day, what's going to be the end result of this? Because end of the day, that the country is trying to move away from the past. Now we are trying to deal with the past in a manner. What's going to be the end result? Because some people believe that this is a process of punishing the armed forces or victorious armed forces who actually fought a battle. So what is it actually?
There is this, we must remember that the whole issue of transitional justice and constitutional amendment or constitutional making process is very much embedded in this resolution.
Right.
Now, if you look at the operative para 16, it is talking about the political settlement. Now, we must understand for so many years in Sri Lanka, in the post-colonial period,
Right.
the major issue that we have not been able to deal with is how to deal with the national question, or how to deal with the issue of governance in the north and east, and also equality for all minorities in Sri Lanka, including the Muslim community, and also the issue of Buddhism and other religions in the constitution. So I think within such a context, the constitution is something that is driving, building the more democratic process and envisioning a new state for Sri Lanka. You can't envision a new state for Sri Lanka without looking at how we are going to deal with the affected communities as a result of the war, 30 years of war, historical injustice to the Tamil speaking people, and the marginalization or the discrimination of the Muslim community that they faced over a period of time, but you know, it happened with incidents during the last 2 to 3 years. So constitutional making and transitional justice have to be linked, because you know, constitution is after all about human rights, about governance. Transitional justice is also dealing immediately with reparation, non-recurrence, truth seeking. What happened to my son? You know, that's what the Truth Commission will deal with, and the Truth Commission will also build in the ground for reconciliation. Now, I think we need to. I'm going to be very, very open and honest about this. You know, the Sri Lankan citizen, the Sinhala public, and we living in the north, some people celebrated on May 19, 2009, the killing or when they saw the body of Prabhakaran, they celebrated. Right. Because the Sinhala community felt that was justice for them.
Right.
They celebrated, right? There was no court. He was dealt with. The problem was dealt with, and they celebrated because they felt that was justice. Okay. Now, what about the Tamil mother, or what about the Tamil person who saw what happened to their son or the loved ones in the same land, in the same vicinity, as a result of cluster bombs or as a result of army intrusion into that area, as a result of the armed conflict? Now, as much as the larger community here celebrated with Mahinda Rajapaksa justice, you know, how do we deal with the woman who is asking, I saw this happening to my husband in front of my eyes, how do I celebrate justice? How do I celebrate the situation without knowing, without dealing with the perpetrator? So after all, we must know, there is a conscience problem for Sri Lankan citizen. You know, what is justice? What is celebration? To the Sinhalese, why don't we give the same mood and the same celebration to the Tamil people who suffered? You know, we are saying we are free. Right. When will they feel free and eat kiribat or pongal or celebrate? So the whole issue of constitutional making or transitional justice have to ask the question, when will we as Sinhalese and the Tamils and the Muslims will celebrate together, enjoying justice as equal citizens without having to deal with this as killing this person, killing that person, and being happy because we killed each other.
Right.
So this whole process of constitution building, the whole question of transitional justice have to deal with that issue of humanity. Call it humanitarian operation or whatever. There was violence. Right. And yes. Can we be happy that justice was done because there was violence with no courts?
Right.
You know, that is why we have to read the resolution carefully. Right. This is also a question of building in processes for justice.
Right.
In Sri Lanka. And we need not, you know, hair-splitting arguments about whether it is hybrid or whether it is domestic. I'm saying, you know, we go to all gods when we are troubled.
Yeah.
It could be St. Anthony's, it could be Lord Shiva, it could be Durga, it could be Lord Buddha. You know, the affected community should be able to go to any court.
Right.
And
right.
The most problematic is in confidence building. We know that the national courts have failed.
Okay, Nimaka, it's a very interesting point that you stopped here. National courts have failed, national mechanism have failed, so therefore we needed something different. And Sarah also mentioned that we need the confidence building of the victims, otherwise the process will fail. So that's a huge challenge. Now we have come to the end of the program, unfortunately. Sarah, my final question comes to you. In your opinion, you are a seasoned campaigner and also a brave fighter for human rights. What are the challenges ahead? Can, as a nation, we can move forward with that? What is your thought on this?
I think the most important thing here is that we have to acknowledge there are certain uncomfortable things that we have to face up to in order to move ahead. We have to be brave and mature enough to do that. We have to ask ourselves, what kind of Sri Lanka do we want for tomorrow? And I've always felt that, the Avishai Margalit argument about, a society which does not, people do not humiliate each other and institutions do not humiliate each other. That's the kind of goal that we must try to aspire to. All the peoples of this country have a right to live in this country as equal citizens. In order to do that, we have to acknowledge what we allowed to happen to each other, what we did to each other. You cannot move ahead on amnesia or denial. You need the truth to be able to move forward.
Thank you. Finally, I would like to ask you, Gihan, maybe one last point you would like to say about the process. And
I mean, I could perhaps elaborate very quickly on some of the other confidence building measures that the government could take. And these are what I call low-hanging fruits. It committed to criminalizing enforced disappearances. Now, our law books don't actually have an offense on enforced disappearances, and you would need to bring that offense into the law books in order to prosecute those who have been accused of that crime. Issuing instructions to the military on the fact that if human rights violations take place, they would be investigated and prosecuted. Strong instructions from the top hierarchy down would be important. And this is also something that was committed to in the resolution, in the co-sponsored resolution. And finally, of course, the review of the PTA. I think that's an important confidence building measure. It's something that the government has committed itself to and I think is on the brink of delivering. So I think these things would build a trust in transition justice.
And Nimalka, one last point, very briefly.
We've also promised to bring in the Witness Victim Protection Act, other than reviewing in the PTA. I think the important thing is to be very honest and truthful, and I agree with Sarah there. The Sinhala citizen, the Tamil citizens, the Muslim citizens, we've all suffered as a result of the war, but the dimensions and the experience are different. Me as a woman, a single woman, differently. The Tamil women faced the war differently. Democracy got stifled. Media freedom was attacked. Journalists died. But I'm definitely not happy. The pace at which the government is moving, because other than Eknaligoda case, the government has failed to deal with the journalists, the assassination of other journalists, including Lasanta. Those investigations are going slow. The confidence building mechanisms need to actually be more grassroots oriented. None of these documents have been translated into Sinhala or Tamil. The discussion is not happening in our vernacular languages. We draw experiences from there. The religious leaders have to get involved in this discussion. The provincial council members and the political leaders at the grassroots level, village level, have to begin to own this as much as civil society is owning it. I do not want the same experience that happened during the ceasefire to happen now. This is a golden opportunity.
Yes.
And we need to take this resolution to the village and ask, do you find the meaning in this?
Okay. Sarah, one final word.
Well, at the end of the day, what we're talking about constitutional reform, we're talking about transitional justice, we're talking about all of us getting together and doing this to rebuild this country. What I would also like to see very much is that there are champions from within government who come out and articulate a bold vision of a new Sri Lanka that we can rally around and move forward. that public education campaign is not something that civil society can do on its own. The government has to come out, demonstrate ownership, and by demonstrating ownership, demonstrate sincerity and vision.
Thank you so much. And with this note, we would like to end this interesting discussion on courting justice. Different times need different kind of courage, and this time we need different kind of courage because we need to rebuild the nation. To rebuild the nation, people have come forward. So we need more people to actually come forward and face these uncomfortable truths. We cannot actually bypass them. We have to deal with them. So that's the kind of a message that we are actually getting it. So there's a process we have started. It's owned by Sri Lanka. It must owned by all Sri Lankans. So therefore, we would like to have more discussions in this nature, and I would like to thank Dr. Saranamuttu, Dr. Nimalka Fernando, and Gihan Gunathilaka for coming for this discussion. And with that note, I conclude the discussion. Good night.